All right. Couple quick housekeeping things for Zoom. Most of you are probably all have been using Zoom for a while. It seems like all of you guys have your cameras off and are tech savvy with that. But just in case, if anybody is brand new to Zoom, just know that your mute button is on the bottom left-hand corner of your computer screen. I think it's in a slightly different place if you're on your phone, but if you just tap your phone or move your cursor on your computer screen and move your cursor down and to the left, you'll see a little microphone. That's the mute button. I don't think we'll have to use that today, but just in case, if there's something just so dire, you can always unmute yourself, but everyone will be muted upon coming in as Ellen is giving her presentation. Feel free to have your camera on or not. We like seeing faces, but we're going to be spotlighting Ellen in just a minute, so we're not going to be seeing many of you, but if you'd like to keep your camera on, that's great. And you can find that button of the start or stop video button, which is your camera on or off, at the bottom left-hand corner right next to that mute button. Again, probably in a slightly different location on your phone. We're also going to be using the chat feature a little bit later on, but I will get into that as we start using it for our Q&A. So letting you know about our programs. Please come to our support groups. We have online support groups for family members. That means any friends and family of those living with mental health conditions, any kind of mental health conditions. It doesn't have to be a formal diagnosis. You might just have an interest or an inkling that somebody has some issues in your family or friends. And we welcome you to our support groups. You can find all information on our website at namiscc.org. We have them every Thursday night for family members and every Monday, Wednesday, and Friday afternoons for those living with mental health challenges. So we also have groups for adults with mental health challenges every Monday, Wednesday, and Friday afternoon. Everything is offered via Zoom. If you don't have a computer or internet access, or your loved one doesn't have a computer or internet access, you can just call in using your phone. It's super easy. Lots of troubleshooting tips on the website, and also you can always call our office or email me if you have questions on how to use Zoom, how to log in. So please check out our website for that. We also have 3 classes starting in the fall. One is peer-to-peer, which is our 8-week course for adults with mental health challenges who are interested in learning more about their conditions and interested in learning about living in recovery. That class starts Wednesday, August 26th. You can sign up on our website, namiscc.org, and you can click on the classes tab, and then under it, you'll see peer-to-peer. You can also always call our office. If you go to our website, you'll see our office in the top right-hand, office number in the top right-hand corner. We also have a family-to-family class starting in September, which is for family and friends of those living with mental health challenges. Lots of great information there, information about how to support your loved one and information about what is mental illness and how do I communicate better, how do I maintain a better relationship with my loved one who is going through this condition. That one we don't have a date for yet, but we are planning a class tentatively in early September and also in October. So again, all the information is on our website, namiscc.org. Go to the classes tab, go to the family-to-family tab. And we also have a family-to-family in Spanish, de familia a familia, and that starts August 17th. I believe that's a Monday class. And that's also a 12-week course for Spanish-speaking family members and friends. Again, everything on our website. We have an Espanol tab that's in the very beginning of our tabs on the website. So please check it out, sign up, look through our website if any of that sounded interesting to you. You want to hear more information about it, also email me. My email is my name, Anastasia, at namiscc.org. That's my cat. And I think that's all I have for you guys. So I'm going to unmute Carol right now and give her the spotlight. Carol, I think you might have to unmute yourself. Spotlight video. You know what?
All right, you can hear
sorry,
me, huh?
Carol. It looks like I can't spotlight you right now because we're looking at the share screen. So just go for it.
Okay. Hi, everyone. I wish I was seeing you all in person. I see familiar names and some of your faces. And gosh, it'd be nice to be there at Live Oak Senior Center together again. But glad that you came tonight. This is a really important topic for us all to understand better. And I'm missing you all. I hope that each and every one of you is adjusting to this strange new world that we seem to have come into now, and getting used to using Zoom and telephone and making your life acceptable in the what I call the new world. So know that mental health is really important right now. So before we go into our topic, just a reminder for you to stay connected to your providers, your family members, sticking with their mental health programs, and you with yours. And know that county mental health is open, trying to keep connections with clients, kind of having a hard time with that. Call the access team if you think you need to get support to your loved one. So now to introduce Ellen Cookman. We're so grateful that Ellen came to join us tonight and help us learn about this. She is the owner of Cookman Law in Palo Alto. She's a certified specialist in estate planning, trust, and probate law. And she received her JD from UC Berkeley School of Law and her LLM in estate planning, trust, and probate from Golden Gate University. She lives in East Palo Alto with her husband and 2 sons, one who has special needs, and a boxer pit bull named Ulysses. And she is a NAMI member in San Mateo. So I welcome you to sit back and enjoy as Ellen takes a deep dive into this important learning for us. Welcome, Ellen.
Thank you so much. I'm just going to share the screen. There it is. Okay. Thanks so much for having me. It's wonderful to be here. And I love NAMI in all locations, but this is the first time I've spoken with Santa Cruz County, so I'm thrilled to be here. Thank you for the introduction, Carol. And let's see if I press this. There it goes. Okay, good. So yeah, a little bit more about me, but really how I came into special needs planning. I think it's kind of an interesting story. I worked at a big firm, Morrison and Forrester, for 3 years doing litigation, and I hated every second of it and completely burned out. And I went to teach for a year at a small private school called Hope Technology School in Palo Alto. I taught middle school math and helped start a high school program. And while I was there, I heard somebody present about special needs trusts. And I thought, I think I could actually do that. And I remember she was like 8 months pregnant with her 3rd kid. You know, I'm like, oh, you can actually have a family and help people. And I had been volunteering in the special needs community already. So, so that was 11 years ago. So I've been in the field for 11 years. And 3 years ago, my older son was diagnosed with high functioning autism. So I went from being, you know, a volunteer and an advocate to a parent. And being able to see the parent side as well. And also there are mental health challenges that run in my family, so I'm also familiar with those. So I love what I do and helping people. And I come from a family of lawyers and teachers, so I especially enjoy, you know, I wish we had more back and forth, but what I would ask you to do is if you have questions as they come up, I ask you to type them in the chat box. And we'll pause a few times during this and I can answer some questions. And then at the end, we will have more time to answer questions. And if you've asked something that we'll talk about in the future or, you know, further on, I'll let you know. Okay, so the goals when you're looking at estate planning, the main goal is really to maximize the quality of life for your loved one. And that could look very different depending on your child's ability, and not just child, it could be a parent, it could be a niece or nephew, it could be a close friend, but really helping them also to be as independent as possible. I think that's something that we all want for our kids. We want to protect our children from financial predators and people who might take advantage of them. We also want to maximize the public benefits that they might be entitled to. And I'll talk a bit about those benefits because a lot of this planning does involve protecting those benefits if needed. essentially what we're doing is we're setting up surrogate financial parents for the kids. And so nobody's going to be as great at parenting our kids as we are. Well, there's some great parents out there, but but we really, we understand our kids so well. We advocate for them tirelessly, and so how do we keep that going if we're not around? And I think that keeps a lot of people up at night. So my goal is to help you guys sleep at night, to know that your kids are really set up for the best success that they can. And then our last goal, even though I'm a lawyer, I hate going to court. So my one goal is to avoid the court system, which in California is costly, it's time consuming, it's public. So if we can avoid it, we try to. Okay, first, so I'd like to talk a little bit about public benefits. What are they? How do they work? So the idea is once your child turns 18, all of a sudden they're an adult. And I want to put that in quotes, right? Which anybody who, actually our niece was staying with us for a little while and she just turned 18. And while she's an adult, there's still some growing to do, But when you turn 18, all of a sudden your income and resources are not attributed to your kids. All of a sudden they're poor. All right, and so they can qualify for certain public benefits. And there's really two main types, and hopefully you can see my mouse cursor here. There's needs-based public benefits, and then there's entitlement-based public benefits. So the needs-based public benefits are dependent on how many resources your child has in the bank. They have to have under $2,000, it's hardly anything, under $2,000 of countable assets. Now, there are some assets that are exempt from that counting. That would include a house, sometimes retirement accounts can be exempt, but mostly they're really not able to own much, okay? So if they're disabled, and basically what disabled means is they have a disability, and because of that disability, they can't work and support themselves. So the category of disability is not as important as the fact that that disability makes them not able to work a full-time job. So for example, Stephen Hawking's, right? He was profoundly disabled, but he wouldn't be qualified as disabled for public benefits purposes because he was able to work and support himself, okay? So if you're disabled and not able to work and support yourself as a result, then you can qualify for either needs-based benefits or entitlement-based benefits. When you work, there's basically two things you get when you work. You get an income stream and you get health insurance. And my hope is that someday health insurance won't be tied to working, but right now it is. So we deal with what we have. So so what people who are not able to work because of their disability need are income stream and health insurance. So if you have less than $2,000 and you're disabled and you can't work, you can qualify for something called Supplemental Security Income, which is SSI. And that provides an income stream of up to $971 a month. It's meant to cover food and shelter. And if you receive even $1 of SSI, you automatically qualify for Medi-Cal, which is California's version of the federal Medicaid system. And within Medi-Cal is something called in-home support services, okay? Now, if somebody has paid into the system, someone's worked for a while and then they become disabled, or someone's worked for a while and then they retire and they have a disabled adult child, then they can receive entitlement-based benefits, which are called Social Security Disability Insurance or Child Disability Benefits. This is an income stream. It doesn't matter how much money you have in the bank, all right? And after 2 years of receiving SSDI, you can qualify for Medicare, which a lot of people are familiar with, another health insurance program. Okay, so the big question comes up, all right, what if I die and then my child inherits a lot of money? Well, that's going to bring them over the $2,000 limit. What am I going to do? How can my child continue to receive their public benefits or qualify for public benefits and still have a safety net of money? So that leads us to the special needs trust. And that's exactly what the special needs trust is intended to do. It's an irrevocable trust. Now, a trust is really, it's an agreement between a person setting up the trust and the person managing it for the benefit of a beneficiary. It's a contract. Okay, there's a lot of different types of trusts out there, but this one that we're talking about right now is it's called a special needs trust. It's intended to hold assets for someone who's disabled. All right, the beneficiary is disabled, and it does not interfere with public benefits. So I say it's like a safety net, and my kids just love jumping on their trampoline outside. So I love that picture. So why doesn't it count towards public benefits? Well, the way a special needs trust works is the person who's the trustee, the manager, is not able to, the beneficiary is not able to be the manager. They can't be the trustee. And the beneficiary, the disabled person, cannot access the money. They can't revoke the trust. They can't control the money. And because they can't control the money, it doesn't count as their money. And therefore, they have under $2,000 of countable assets. Even if there's $1 million in the special needs trust, they still qualify for public benefits. So it's a really wonderful tool to provide for someone with special needs, but they can continue to receive their health insurance. They can continue to receive their income stream. They can continue to qualify for different housing programs, which a lot of times public housing programs out there for kids who are disabled require you to qualify for public benefits. All right, there's two main types of special needs trust. There's what we call a third-party special needs trust and a first-party special needs trust. The main difference is where the money came from. And what I mean by that is who put the money into the trust, all right? So for a third-party special needs trust, that's the one that most of you will be setting up for your kids. You're the person putting the money into your child's trust. You are a third party to your child. Now compare that to a first-party special needs trust. That's if a disabled person has their own money. For example, if they were able-bodied and worked for a while and then they became disabled, or if they were disabled and then they received an inheritance and it goes straight to them. It didn't go to a special needs trust, it goes straight to them. Then that disabled person can turn around and put their own money into a first-party special needs trust. All right, so which one do you choose? It depends on where the money is coming from. Now I can tell you a third-party special needs trust is more beneficial because upon the beneficiary's death, the money goes wherever the trust says. It just goes straight to that person. For a first-party special needs trust, Medi-Cal brings a reimbursement claim. So they want their money back. So first, any money is paid off the top. After the beneficiary dies, the money is paid off the top, and then only after that happens does the money go where the trust says. All right. Also, a first-party special needs trust is restricted in that only the beneficiary themselves or a parent or a grandparent can set it up for the child. And also, the child can only put money into it until they're age 65. Once they hit 65, they can't put money in anymore. So here's a comparison chart. So we have the third-party special needs trust versus the first-party special needs trust. And I put the code where it comes from. Sometimes we call it a D4A special needs trust. That's the same thing as a first-party special needs trust. So anybody can set up the third-party special needs trust except for the beneficiary. And at the beneficiary's death, it goes wherever the creator of the trust says it should go, compared to the first-party special needs trust. Okay. Now there is also a trust called a pooled trust. That's like a first-party special needs trust that's run by a nonprofit organization, where they basically pool together a lot of smaller first-party special needs trusts. The nice thing about that is that if the disabled person is over age 65, they can still put money into a pooled trust. Okay. Okay, so I think the hardest choice to make is who is going to be trustee of the special needs trust. In the beginning, you are, the parent, the grandparent, whoever's setting it up, but then what happens when you're gone? Who's going to take over? Who's going to be the surrogate financial decision maker? All right. So we look at, well, who's available, right? A lot of people might choose a trusted family member, maybe a niece or nephew. You usually want to choose somebody younger than you, who's going to be alive for a lot of your child's life. Or maybe you'll choose a friend. But sometimes those options may not be the best choices. A lot of times I'll suggest not choosing the sibling of the disabled beneficiary, particularly if the disabled person has mental health challenges, because you want if there's a typical sibling, you want them to be friends. You know, you want them to be supportive and, you know, be able to live side by side. You don't want them to be the gatekeeper to the money. That can cause a lot of resentment between siblings. So, you know, you have to think carefully about who am I going to name as trustee. There are professional choices out there, and I often recommend them. There's a private professional fiduciary. Those are individuals who, and that should just have one bullet point, a private professional fiduciary. There are individuals who act as trustees of trusts. They're licensed by the state of California, and I think they do a fabulous job. But it's good to interview them and see if they're a good fit for your child. The main drawback, I think, is that a lot of them are older than us. You know, they might be in their 50s or 60s. And if your child is 10, 20, 30 years old, they're not going to live for the rest of the life of your child. So you want to see if they have a succession plan. They usually charge hourly. And there's really only a few. If your child has mental health challenges, there's a few that will act as trustee. A lot of them choose not to. And the same thing goes with banks. So banks and trust companies, there are some banks out there that will act as trustee of special needs trusts, and some of them I think do a very good job. One of the drawbacks, and one nice thing is they have the longevity, right? They'll either be around, or if for some reason they give up their trust company, somebody else will acquire it. All right. One drawback is they tend to charge more. They'll charge usually a percentage, maybe 1.25% of the fees under management per year. So that can deplete the trust assets, but they really know what they're doing. So, you know, sometimes people do a combination of these things. They might say, hey, I want a family member to act as co-trustee with a bank. And that can work. So you have a family member who's a bit more involved. I did mention the nonprofits and pooled trusts. So there are some nonprofits out there who act as trustee of special needs trusts. And then, but one drawback of naming a professional is, well, do they really know my kid? How do I know when I'm gone that they're going to do the right thing? So the nice thing about a trust is it doesn't go through the court system. But the drawback is that it doesn't go through the court system. So what do I mean by that? Well, there's nobody to oversee it. If the trustee's not doing a good job, how, you know, if you have a child with disabilities, they're not able to oversee this. They don't know if somebody's doing a good job or not, right? So there are a few options for oversight. The most popular one that I've seen nowadays is actually naming somebody called a trust protector. So this would look like a family member, maybe a sibling or a niece or nephew who doesn't want to be involved in the day-to-day, or they just have their own lives and they can't act. The job of being a trustee of a special needs trust is a big job. If any of you have ever acted as trustee of a trust, it's a thankless job. There's a lot of work to do. There's a lot of fiduciary responsibilities. But acting as trust protector, your job is a lot more limited. So basically, you have oversight roles. So you look over the books once a year, you get accountings once a year, and you have the power to remove and replace the trustee. So if the trustee's not doing a good job, if they're withholding money, if they're not communicating with the beneficiary, then the trust protector can swoop in and help change things around to make it better. But they're still not involved in the day-to-day decision making. So that can be a good role for a family member who wants to be involved but can't do the heavy lifting of the day-to-day management. I did mention co-trustees. One setup that was popular for a while was an advisory committee. So you'd have like the person's psychologist and their caseworker and the favorite uncle, and they'd all meet up once or twice a year and make recommendations for the trustee. The problem is that can get to be pretty expensive to involve quite a few people. So I don't see that as often, but it does come up sometimes. Okay, one thing that I always recommend is that parents write a letter, and this is separate from the special needs trust, okay? I write a memo of intent, basically describing their child. Everything, it's like a mind dump. Everything that you wish your trustee would know, you write it down. You know, what makes them happy or sad, or what do they do every year, you know, if they participate in the Special Olympics, if they, you know, do different things, if they're close friends with a certain neighbor and you want to continue that relationship or not. These are all very important things to communicate to the successor trustee, particularly if they're not a family member and they're not always involved in your child's life. So I always recommend that. Okay, one thing I'd like to share, and this is a recent event in 2020. You may be familiar with the Secure Act. And this changed a lot about how retirement accounts work. One of the biggest changes is that it eliminated the ability for a non-spouse to inherit an IRA, you know, 401k, IRA, SEP IRA, 403b, everything like that. Not a Roth IRA, because Roth IRAs are post-tax, but all pre-tax instruments like that. It eliminated the ability to inherit the IRA and then stretch them out over your calculated lifetime. Okay, so this was a big blow to a lot of people. Now it all needs to be distributed over 10 years of the person inheriting the money. However, there's some caveats, and one of the exceptions to that elimination are disabled individuals. So if a disabled person or that disabled person's special needs trust inherits an IRA, you can still stretch it out over that disabled person's lifetime, okay? And the required minimum distributions don't go straight to the disabled person and interfere with their benefits. They stay in the special needs trust, all right? So it's a really wonderful planning opportunity. So what I used to see is, and the trust, by the way, the special needs trust has to be drafted. I'm not going to go into the details right now, but it has to be drafted properly and very specifically. So because it has to be drafted right, people would get nervous and they'd say, well, I'm just going to leave every, you know, my retirement accounts to my typical child because we know they can stretch it out. Now we see a lot of people changing that around. So instead, we see people naming their disabled child's special needs trust as the beneficiary of retirement accounts, and maybe leaving other assets in a different way to their typical children. Okay, so what I'd like to do is pause for a minute or two and see if there are any questions. I'm not sure, Sophia, if any questions have come up in the chat room.
Yes, we do have one question referring to the slide that outlines the income stream and health insurance. Someone was wondering, is owning a car exempt from the needs-based criteria?
Yes, you can have one car. I think there's a value limit, but I don't think they're that strict about it. So yes, you can have one car in addition to a house and some retirement accounts. Mm-hmm.
And we just got another question. What does trust as a beneficiary mean?
Trust as a beneficiary. I'm not quite sure what that question means. Whoever asked it, do you want to type maybe a little bit more clarity?
And in the meantime, can a person who gets SSI also get SSDI? Yes,
they can. Okay, so SSI guarantees an income stream of up to $971 a month. If you have an income stream from somewhere else, like you're working or you're receiving, say, $400 a month of SSDI, then SSI supplements it. So you can have $400 of SSDI and then $571 a month of SSI. Similarly, some people receive both Medi-Cal and Medicare. We call them Medi-Medi. So there are some people who receive all 4 types of public benefits, and they might be receiving Section 8 housing benefits, and they might be a member of the regional center. So, so they all interact in different ways.
Can you say something about the connection between special needs trust and child support for disabled persons over 18 years old?
Ooh, okay. Boy, that's a little bit complicated, but what you can do, so the issue is child support going to interfere with SSI benefits? And you can, and yes, it will interfere, but you can fix that. You can go to court and get a court order irrevocably assigning the child support to a first party special needs trust. Okay, that's a lot of gobbledygook, but you know, we could talk offline more about how that would work. So it is possible to do it.
And someone is wondering, how do you get SSDI?
You have to go to Social Security Administration and apply. And a lot of times when you apply, you're denied first. So be prepared for that. And unfortunately, you know, so you might have to appeal. A lot of, I think, they deny people on purpose to see if you're really serious about it, because that's how they weed people out. So, you know, there's, it can be a difficult process, but I think it's worth it. So I encourage people to try and to go apply with Social Security Administration.
In your experience, do you share the information with the affected individual before you're, meaning do you inform the affected person that their inheritance is being taken care of by another individual?
Well, it's not really up to me, it's up to the parents to share that information. And sometimes I encourage parents to. I encourage parents to be as translucent, as transparent as possible. But you know, I think parents will do what they feel is the best for their children, whether it's to share that information or not.
And a follow-up from the question, what does trust as a beneficiary mean? The person asking the question says, I thought you said that you can name the trust as a beneficiary for the non-disabled child.
You could, so as I mentioned, there's different types of trusts. The type of trust that we're talking about right now is a trust for a disabled person. Now that you can have a special needs trust and the disabled beneficiary is not receiving public benefits, that's okay. They don't have to be receiving them, or sometimes people get better or worse. But the structure of a special needs trust makes it possible for the disabled person to receive public benefits. Usually a non-disabled person is not the beneficiary of a special needs trust, although occasionally you can set it up that way.
Can one special needs trust be divided between 2 people?
Yeah, I've seen families that have a couple of kids with special needs and they set up one special needs trust. Usually I don't recommend setting it up that way, but I have seen it done.
How about if the adult child needs a caretaker?
So the special needs trust can pay for a caretaker. A special needs trust is actually very flexible. It can pay for many, many things. It can pay for a trip to Disneyland. It can pay for fun things. It pays for caregivers. It pays for anything that the child needs. It's not supposed to distribute cash directly to the child because that could interfere with the income stream, right? That would reduce dollar for dollar what somebody might receive from SSI. But other than that, you know, it can pay for just about anything. Usually the trust will pay the vendor directly or pay for the rent, or, you know, or sometimes you can give a disabled person a credit card that has a limit. And then the trustee will pay off the credit card every month.
Another person asks, my son was disabled before age 18. Does he receive some of my Social Security benefits when I die?
He should. He should receive 3/4 of your Social Security benefits. Mm-hmm.
And someone is asking if you do private consultations.
I do. And my last slide, I encourage you to call our office. Okay. So let me move on, and then we can always, you know, go back to other questions. because I want to make sure we have plenty of time to talk about the ABLE account. I love the ABLE Act. Okay, so what is this? So I want to tell you a little bit about how this came about. Apparently there is a group of families, parents of kids with Down syndrome, and those kids were adults and they were working, but they had this $2,000 limit. Every month they had to spend down everything that they had to below $2,000, and they're like, well, that's not fair. You know, isn't this like America? We want people to be able to save and spend money, and why are we doing this? So they came up with a great bipartisan solution that sailed through Congress, and it was enacted in 2014, so it's still pretty recent, and it's called the ABLE Account, Achieving a Better Life Experience. The idea is it's basically a savings account for a disabled person, okay? And this person can have one account. So you can't set up, you know, 3 accounts, or one in California and one in Ohio. You get one account, and everything that's in it does not interfere with public benefits. That account can receive up to $15,000 each year. So once it hits receiving $15,000, it's stopped from receiving any more. So it's not like grandma can put in $15,000 and somebody else can put in $15,000. It just gets $15,000 that year. So it's imperfect. It can't receive a ton of money, but it can receive some. And it's modeled after a 529 plan, an education savings account plan, which, if you're familiar with it, the money that you put in, it's post-tax money that you put in, but it grows income tax free. And if you make a distribution for, in this case, a qualified disability expense, which is actually defined as pretty broad, then you don't have to pay capital gains on the distribution. So it's very nice. Now, I did put in that it's a plan with a Medi-Cal payback provision, but, okay, so it was originally designed to be kind of like a first-party special needs trust, that when the disabled person died, Medi-Cal wants their money back and they'll bring a lien against it. Well, each state had the option to waive that payback provision, and indeed California and a couple other states have chosen to waive the Medi-Cal payback. So upon the beneficiary's death, the money does not go to Medi-Cal. Yay! That's good news for us. All right, so to be eligible, the beneficiary must have a qualifying disability. So what does that mean? That means if you're receiving SSI or SSDI, you have a qualifying disability, all right? Otherwise, you basically need to get a doctor's letter stating that you have a qualifying disability. And I don't know the exact language, but I think you can find it online. And you don't submit that letter anywhere, you keep it in your file, all right? And here's the big limitation. The disability must have manifested before the person turned age 26. That's a limitation in the mental health community, because sometimes mental health challenges manifest in your 30s or even 40s. It had to have manifested before age 26 in order to qualify for an ABLE account. In Congress, there's some people who are trying to increase that age to age 46, but they haven't been successful yet. So it's to be used for qualified disability expenses and only one account per person. Okay, you can put into $15,000 per year. Now, where does that number come from? It's actually, if you're familiar with gift taxes, that's the annual exclusion amount. That's how much you can give away to as many people as you want every year and not have to report it to the IRS. So when the annual exclusion amount goes up in a few years, the contribution limit amount will go up. If the ABLE account, you know, it's going to grow, if you put in $15,000 a year, at some point it'll hit $100,000. At $100,000, SSI, Supplemental Security Income, is suspended. But the beneficiary can continue to receive Medi-Cal, all right? And I already talked about the payback requirement being waived in California. All right, and a couple years ago, they established that if you have established a 529 savings account, an education savings account for a disabled person, and they're not going to be using that, perhaps because of their disability, they're not able to go to college, you can roll over $15,000 each year from a 529 plan to an ABLE account. Okay, and then this last one I think is pretty exciting. So if you have a beneficiary who's working, if they're working a part-time job, they can contribute more than the $15,000 cap. So if $15,000 already went in, they can contribute another this year, sorry, I should say 2020, another $12,760 of their earned income. But they have to not be participating in a retirement plan, because Congress kind of figured, all right, that's kind of like providing for retirement for a disabled person. And as of last year, a CalABLE account is now available in California. We always have a cutesy name, so our name is CalABLE. The only place you can establish it, so don't go to Wells Fargo and say, hey, I want to set up a CalABLE account. You go online to this site right here, www.calable.ca.gov. When you click it, you'll see a screen that kind of looks like this, and then you click on the Open an Account thing, and they'll ask you for the beneficiary's social security number. If the beneficiary won't be managing it, but somebody else, like a parent, will be managing it, they ask for your social security number, and you do need to set up a bank account, and that's where the money will be held. And CalABLE is run by TIAA-CREF, I believe, and so those two kind of communicate with each other with the front end account that is held at Wells Fargo or wherever you bank. Okay. And one recent thing that's exciting is that now a prepaid Visa debit card is available. So that makes it easier for beneficiaries to withdraw money from the CalABLE account. All right, so I just dumped a lot of information on you about CalABLE account. So I wanted to pause and see if there's questions about the account. Sophia, any questions come up?
Yes, can a special needs trust pay for housing?
Ah, okay. Yes, all right, okay. So this actually, let me give you, why am I so excited to answer this question? You're like, well, who cares, right? But okay, so let's go back to SSI. So remember on that screen where you have SSI and SSDI and Medi-Cal and Medicare. So supplemental security income is meant to pay for food and housing. However, if somebody else is paying for the beneficiary's food and or housing, then the SSI check is reduced by about a third, by about $250. So then they'll be receiving about $650 a month, which isn't as good as $971 a month. All right, so here's a way to get around that. You set up a CalABLE account, which counts as the beneficiary's own money. Okay, the reason, so wait, let me back up. The reason why SSI is reduced is because the beneficiary is expected to use all of the SSI money to pay for their food and housing, which, you know, $971 a month in the Bay Area to pay for food and housing, like, that's a joke, right? People usually supplement it, but to the government, they say, hey, you should be able to do that. And if somebody else, if a third party is paying for your food or your housing, you don't need all $971 a month, and we're going to reduce that amount. Crazy, I know, but that's the way it works. Now, let's say that person now has a CalABLE account or an ABLE account in another state, and somebody puts $1,250 a month into that CalABLE account, and then the beneficiary turns around and pays their food and their rent from that CalABLE account. The Special Needs Trust has put $1,250 into the CalABLE account, and now the CalABLE account is paying for food and housing. The SSI check is not reduced because it's the beneficiary paying for their own food and housing. I know it sounds like you're getting around something you shouldn't, but it works. Okay, so to answer your question, yes, a special needs trust can pay for food and housing, but it will decrease SSI, but I've just provided a way to get around that decrease. So by using the CalABLE account as well, you don't get the decrease in SSI, and you can still pay for somebody's food and housing.
This person is in a situation where their brother-in-law has Medi-Cal and is about to get state disability. Apparently, they're going to pay him retroactively. and he's going to get a large sum, it sounds like, and I'm afraid that he will lose his Medi-Cal and CalFresh as he will have more than $2,000 in the bank all of a sudden.
Mm-hmm.
His medicine, doctor, and therapist will eat up the large incoming sum very quickly. I do not know how to help him with this situation. He is hoping to have some of this incoming sum to move out on his own, but it sounds like he can't save this money and keep his health benefits. He's 35 years old.
So that could be, you've just given a really good example for where a first party special needs trust could be useful. He could put, you know, he can try to spend it down, but it sounds like he wants to save some of it. So he could set up his own special needs trust and put some or most of that into the special needs trust, and then he can take his time using it up.
What kind of income can go into an ABLE account?
Any income or resources, really. I mean, it has to be cash, so it doesn't hold stock or how, you know, real property, but it's basically cash.
And this is a clarifying question. Did you say that if above $100,000 in ABLE account that SSI is not lost in California?
SSI is suspended, so it is lost, but once you go down below 100,000, SSI is resumed. So it's not like you're bumped off of eligibility, they just stop paying you at that time. So most people will keep their ABLE account below $100,000 so they can continue to receive SSI.
If someone is on SSDI, does the $100,000 limit apply in the ABLE program? And if not, what happens when the person reaches $100,000?
So SSDI is not affected by income or resources particularly. It's the ABLE account by itself that has the $100,000 limit.
How does this work if your disabled child lives in a different state?
Anyone can set up a CalABLE account. They may choose to set up an account in their own state because every state, just about every state now runs a CalABLE account. You can always have a special needs trust established here in California, running, you know, paying for needs in another state. But I do suggest if your child is in another state and needs to qualify for benefits, you should consult an attorney in that state to make sure that if you have a special needs trust, then the trust is functional in that state, does not disqualify the child from public benefits in that state.
Is the money in the CalABLE account subject to the rules of spending in special needs trusts?
No, it's a little bit more restricted because the CalABLE account is supposed to be for qualified disability expenses. So it's basically anything that you might need: food, transportation, housing, get around stuff. It's not supposed to pay for a trip to Disneyland, for example, really fun stuff or hobbies. Special needs trust, on the other hand, can pay for all those fun things and more, as long as it can last for the beneficiary's lifetime. Okay, maybe we'll take one more question and then we'll move on just to make sure we get to the end.
All right, last question. Can you have a CalABLE account if the person is not receiving SS disability benefits? What kind of proof of disability do you need? And what if the disabled person lives in a different state, not California, but you are supporting them?
So basically you need a doctor's letter that, that states that they are disabled. And there should be information on the website that goes into what that doctor's letter has to say. Okay, so let's move on. There's a few other topics I wanted to just touch on, but those are the main topics for tonight. Okay, so I've compared the two. There's some charts, who can control it, who benefits, and I should have covered all this information. Okay, here's another comparison chart. How much can go in. So you can see from this example, so an ABLE account can only receive up to $15,000 a year. So it's really not meant to supplant a third-party special needs trust, because hopefully you'll be able to leave more than $15,000 to your child in an inheritance. And so an ABLE account wouldn't be able to take all of that. So that's meant to go into a third-party special needs trust. Okay. Then we look at income tax issues. And this is the what types of distributions, which we just covered. Okay, I did want to talk a tiny bit about the revocable living trust. So your child has a special needs trust, but you guys also need a trust for yourself. And many of you, I'm sure, have a revocable living trust set up, I did want to talk about a few updates that you might need, just changes in the law. So a revocable living trust, the goal is to avoid the probate court. If you have more than $166,250 in your name without a beneficiary named, and you die, then that money goes through the probate system. All right, it used to be 150,000, then it went up a little bit just to confuse us. It was a nice round number, and now it's a strange number. So for example, if you own a house, then you need a revocable living trust. All right, so it's intended to hold your assets. You can change it at any time. You don't need a separate tax ID number. In the trust, you say who gets the money upon your death, who are your successor trustees. So in that way, it operates as like a special needs trust. Okay, so this is the type of trust we used to see. So if you drafted your trust, 10 years ago or more, and you're a married couple, your trust may be drafted like this. It says at the first death, everything splits into two subtrusts, the A trust and the B trust. We used to do that because the estate tax exemption used to be really low. It used to be like $600,000 or $1 million. That's the amount that you can pass to the next generation without paying estate tax, okay? And we didn't have anything where it could be transferred between spouses. So it's basically use it or lose it. So the deceased person's half of the money went into the bypass trust, and the survivors went into the survivors trust, okay? And then things went to the children at the second death. Well, in 2013, things changed quite a bit. We got the higher estate tax exemption. The estate tax exemption was set at $5 million per person, indexed for inflation. And in fact, this year, the estate tax exemption is huge. It's like $11 million and change per person, okay? So probably most of us on this call, unfortunately, don't have an estate tax problem, right? The other thing that developed was what's called portability. So to port is to transfer. So that says, okay, the first person to die, they have their unused estate tax exemption. Well, the survivor can elect to transfer the deceased person's estate tax exemption to the survivor. So now the survivor has twice the estate tax exemption. So now the survivor can get all the money and can get all the exemption. So a lot of people are simplifying their trusts to not have that A-B split anymore. Okay, and then at the second death, it still goes to the kids. Okay. You may choose to keep the split for control purposes because the B trust is irrevocable, it can't be changed. So especially in blended families, it's still popular to do the split. So you make sure that, if the survivor remarries or wants to give it all to the guru, or the caregiver exerts undue influence, then at least the deceased person's half will go to the kids as they intended. All right, so a lot of us out there, like me, I have a child with special needs, and I have a typical child, and the typical child often gets overlooked. Well, how should your typical child receive their inheritance? One way you say is, hey, they're old enough, they're healthy, they can do what they want, they receive it outright. Another popular way is to say, well, they get it at certain stages. So let's say, Isaac gets a third at age 25, a third at age 30, and then a third at age 35. So if the idea is if he blows it at 25, then at least he has another chance when he's a little bit older and maybe a little bit more mature. Another option that I've seen that's become more popular is called a lifetime trust. So that says, okay, the typical child inherits money into a trust that lasts for that child's lifetime, but the child can become trustee of their own trust. So now they're able to manage things and make decisions. If they want to buy a house, then the trust buys the house. They use the trust to buy the house. But that does provide some protection from divorce because everything is segregated, it's their money, and it also provides some creditor protection. So that can be popular. And then of course I put in special needs trust. The other thing you need to think about is, God forbid, what if all of you die at the same time or your kids die before you? Where would you want your stuff to go? that I call that the Titanic, you know, or the alternate distribution. So sometimes people say, hey, I wanted to go to certain, you know, individuals and percentages, maybe to a group of people, go all to my nieces and nephews, or sometimes people say to charities. All right, and I'd like to say just a little bit about conservatorships. These go through the court system. So this is one place where you really can't avoid it. So the idea here is if you have a loved one who really can't make their own decisions, then you can go to court and ask the judge to allow you to make decisions on that person's behalf. Now, there's three main types of conservatorships that you'll see out there. One of them is a general conservatorship, and usually that's for the elderly or somebody who's in a coma or has dementia, and you're just asking to take over their affairs completely. You also have limited conservatorships, and that's for somebody who wants to conserve a developmentally disabled individual. And I actually work on those. I do limited conservatorships, but only in San Mateo and Santa Clara counties. Okay. The third one and this is the one that comes up for mental health challenged individuals, is an LPS conservatorship. It's if somebody who, because of a mental disorder, is gravely disabled and they're unable to provide for their basic needs. Okay, and just to, you know, to cut to the chase, it's very difficult to get an LPS conservatorship. These are the basic steps. You need to have a psychiatrist who do an evaluation. Then the psychiatrist makes a referral to the public guardian's office. So there aren't any attorneys who actually initiate conservatorships, and the parents cannot initiate a conservatorship. Only the public guardian's office can. They file, the guardian files the petition, and then the court gives the order. And it really only lasts a year, and then it's reviewed. If you want more information about LPS conservatorships, I'm really not the person to talk to because I don't practice in this field. I am aware that Santa Clara County, their warm line, they have a lot of information on LPS conservatorships, so I would refer you to speak with them. But I do just want to, you know, as you're looking at all the tools in your toolkit, it's really difficult because a lot of times when you have someone with mental health challenges, they're making really poor decisions. And you'd really like to step in and help them to make better decisions. So if it's really hard to conserve them, what are the other options? Well, you can have them sign, and everybody who's over 18 should sign these two documents, an advanced healthcare directive and a durable power of attorney. So the advanced healthcare directive is for medical decisions. So that allows somebody else to go talk to the doctors or access your medical records. And then usually it's if you're incapacitated, if you're unconscious. But you can send it up, so even if, you know, if you want a family member to come join you and you have capacity, you can do that. And then a durable power of attorney is allowing somebody else to sign for you for financial decisions, to go to the bank and access your bank accounts, that sort of thing. There is something that's becoming more popular called supported decision-making. And the idea of that is really getting a team of people to help the disabled individual to live as independently as possible. Sometimes this can be popular when, I know for me, it's really hard to listen to my mom, for example, you know, and you guys, your kids may not want to listen to you, but they may be more willing to listen to a team of individuals who they trust, and they've built this trust. And so if you go to this website, supporteddecisionmaking.org, that can give you more information about how to set this up for your loved one. Okay, so I'm on Facebook and LinkedIn. I also do a quarterly newsletter. So if you wanted to join that, you know, you can send our office an email. We can put you on the list. Or as somebody mentioned, do we do private consultations? Yes, we do. That's mostly what I do with my time. And feel free to contact us to schedule an appointment. So that's all the information that I have, but I'd love to open it up if there's other questions. And please, feel free to reach out to our office. So Sophia, are there other questions that people might have?
Yes, there are. I also wanted to say that there are lots of compliments. People are super thankful for you and this topic, and they're learning a lot.
Great, I'm so glad. This is actually fun for me. Once I get over the initial jitters, and I'm like, yeah, this is good, because people need to know this information. It's very difficult to find this information online, and California works very differently than other states. So I'm glad to pass along what I think is essential.
So the first question is a situation: if a person with mental illness is well enough to have earned some income that he puts into a CalABLE account and possibly into a first-party special needs trust, will his SSDI and HUD Section 8 voucher be in jeopardy because he's no longer considered disabled enough?
Well, I think the issue, Section 8 housing works differently than most other public benefits. They really look at your income level. So it's really, it's a low income issue. So it's not really related, I think, to whether you put your money in a first party special needs trust or an ABLE account. Now, putting your money in a first party special needs trust can sometimes slightly affect your Section 8 housing voucher. But unfortunately, each public housing authority approaches it differently. So I can't say for sure whether or not it will be impacted. And it's difficult to sort that out. But so yes, it could be slightly affected.
Can an ABLE account be the account for a small family business? We want him to have all the money. Can it go directly to him, or will he get taxed?
Small family, okay, I'm sorry, I just got this update thing. Can you repeat the question, please?
Yeah, of course. Can an ABLE account be the account for a small family business? We want him to have all the money. Can it go directly, or will he get taxed?
So it's not really intended for a family business. I mean, it's really intended more as a savings account. So it wouldn't be like a professional corporation account. There may be other savings options that, as it grows, that there wouldn't be capital gains tax when it's removed, but it's really not intended for that.
Can a first and third party trust be held simultaneously?
Yes, sometimes people have both.
Can they have a CalABLE account and a checking account with under $2,000 and keep SSI/SDI?
That's right. Yep, you can have both.
My son receives SSDI from my husband's SSA. What happens if my husband dies and I am not eligible as a beneficiary?
Okay, so the son receives SSDI from the dad's record. So the son's getting child disability benefits, and usually if dad retires, son should get, and son is disabled, son should get half of what dad receives. Once dad passes away, the son should get 3/4 of what dad received during his lifetime.
All right, that is all we have. Lots of thank yous. Fantastic speaker and topic. Thank you for putting the info for this webinar in the Santa Cruz Sentinel paper.
Okay, wonderful. Thank you so much, you guys. Great to speak with you. Thanks for joining.
Thank you so much, Ellen. That was just really informative and clear. And I'm sure you'll be getting phone calls in the future because it's so complex.
It's true. All right.
Anybody else have something that they want to put a chat up about? Thank you for coming. We had 56 attendees tonight. It's so nice to have them all here. Anything you need to add, Ellen or Anastasia?
I just let me go over the chat feature just in case someone out there is like, where is this chat that everyone's talking about? If you're on a computer and you use your cursor, just scroll down to the bottom. There's a little rectangle that says chat. And if you click on it, you'll be able to see that chat box that we've been mentioning. I also want to remind everyone about our classes coming up. We have peer-to-peer, family-to-family, and familia-familia in the fall. And we have free drop-in friendly support groups online regularly. For family members, it's every Thursday. We have some specific to family members of youth right now. And we also have groups for adults with mental health conditions every Monday, Wednesday, Friday afternoon. You can find that on our website.
I have one more thing. If anyone would like to receive our emails, you can send an email to info@namiscc.org, and Anastasia will get you on our news list.
Absolutely. Oh, it does look like we have a couple more questions, Ellen, if you have a few more minutes.
Sure, yeah, if people have to go, that's okay, but okay, yeah, go ahead. Or actually, I can read it now.
Great.
Okay, what are the first steps to helping my brother-in-law get a first-party special needs trust set up ASAP? Well, feel free to call our office. I'd be happy to help you. Okay, my son gets benefits after my husband died. He has Section 8 housing. We pay $500 from Social Security towards rent. That's great.
Ellen, would you mind putting the slide with your information up right now, just in case anyone missed that?
Oh, sure. There we go.
And then I also got a couple questions about the recording of this event. We will have this on the front page. You should have a link to it by next week. So just look out for that, namiscc.org.
Wonderful. All right, thanks everybody.
All right. Thank you, everyone. Have a wonderful night. We hope to see you at our programs. Next speaker meeting should be September. So keep checking our website for that information. Have a wonderful evening.
Thank you, Annie. Thank you, Anastasia and Sophia and Ellen. Thank you so much. Hi, Diane.